Welcome to A Case for America. This is Austin Hepworth. I'm here along with Michael Hepworth. And we look forward today to talking to you more about the 14th Amendment. I think this will be our last podcast, at least for a little while, on the 14th Amendment. And we hope you've enjoyed going through some of the other issues. This one will bring in to its discussion a very current issue, one that will be heard this week, I believe, in the Supreme Court. And we're currently in the week of February 5th, 2024. And we're going to be talking about President Trump and the Insurrection Clause of the 14th Amendment. This one just happened to coincide perfectly with our natural progression in this podcast. But it is one that, as we've looked at it and looked at the issues, is very interesting in the sense that the Constitution, from our perspective, appears to have a decent size hole in it as it relates to this specific issue. So it has created litigation, has created uncertainty in many states, created a lot of political unrest for people, and we want to go into it to look at what the Constitution does specifically say, what it doesn't say, to help you better understand what the Supreme Court's looking at, what some of the stakes are that come out of this, either way. And we're not necessarily arguing for or against any particular point in this. The goal of this podcast is education, at least for this particular episode. And we hope that you can look at this and be able to better understand some of what's at stake here. So, coming to where we're at, we will share the screen. So if you're viewing this on YouTube, you'll be able to see it. If not, we will read it. But if you look at the 14th Amendment to the U.S. Constitution, Section 3, it says, "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state." So you can't hold these certain offices it talks about. If it says you previously took an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state. So if you served in Congress, served as an officer of the U.S., served as in a state legislature, or served as the executive or judicial officer of a state, and you took the oath to support the Constitution of the United States, you can no longer be a senator in Congress or hold any office under the United States if you shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. And then it says, but Congress may, by a vote of 2/3 of each house, remove such disability. So our current situation in America is that the Colorado Supreme Court has determined, they've said that, in their opinion, President Trump engaged in insurrection with the January 6th situation and therefore cannot hold office. And so they have said he cannot appear on the ballot. I believe the Maine Secretary of State did the same. And it wasn't as much a judicial proceeding as it was the Secretary of State going through saying, we've made this determination, looking at the facts and evidence, and we're not going to let Trump on the ballot. The claims have also been made in other states, including Michigan, where groups tried to keep Trump off the ballot. And other states said, this isn't our domain as a court to decide this. Some of them said the state legislature may have to act. Some of them said, other parts of government may have to decide, but it's not for us to decide. And so there's currently a split in America between the states as to what this means. And so in diving into this, we had the question of simply asking, if someone wanted to run for president who wasn't 35, because the Constitution mandates that a president be at least 35 years old. what happens if a 25-year-old wants to be on the ballot? Who is it that keeps them off? And it's, from what we can tell, there's no easy answer to that question. And then the insurrection items harken back a little bit to the Obama birth certificate issues, where people allege that he wasn't a U.S. citizen, and they wanted to either have him kicked out of office or not allowed to run again. And there were lots and lots of lawsuits filed by people over that. Basically, all of them were dismissed by the courts without getting into an evidentiary review. So the courts didn't go through and force him to produce his birth certificate. They just said, you citizen bringing this claim, you don't really have standing to be here. You're not the proper party to come assert this claim to us. And they would dismiss these cases. And one of the issues with a lot of the cases is that they came after the election. People were trying to disqualify President Obama after people had voted for him. And courts are very reluctant to undo elections once they've taken place. They know that could produce some pretty serious societal ramifications, views of the court. And so they typically will only address election issues if they're raised prior to or during the election, not after. With Trump, this challenge did come early enough. And so we're here looking at what the options are. And so one thing to note with this, there is something called the Federal Election Commission that exists. And the Federal Election Commission, you could say, well, are they the ones that are kind of the gatekeeper of whether you're qualified or not? But typically you only have to register with them as a candidate, federal candidate, once you've raised or spent a certain amount of money on running. They're in charge of the campaign disclosures, and they're not necessarily tasked with overseeing qualifications for office. Now, if we go to the Constitution itself, if we look at Article 1, Section 4 of the Constitution. So Article 1 talks about about Congress. And so Article 1, Section 4 is titled Elections, and it says the times, places, and manner of holding elections for senators and representatives, so this is for Congress, shall be prescribed in each state by the legislature thereof. But then it says, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. So time, place, and manner, the Constitution gave to the states unless Congress overrode them. And so traditionally, elections for federal government are held by the states. Each state conducts those elections, and each state gets to choose kind of how people get on the ballot, how they go about that. It's different state to state. There's not a one size fits all approach to the United States for how people get on the ballot. And so then the Constitution does mention if there is a qualification issue, so if someone doesn't meet the qualifications prescribed in the Constitution, what happens with that? And it says here that in Section 5, it says each house shall be the judge of the elections, returns, and qualifications of its own members. So that means if there is an election dispute, if someone's under the age required, so a senator, I believe, is supposed to be 30, if someone's 29, the Senate itself would hear that dispute about a senator and determine the qualification for its own members. So again, it's a system where states do the election. They have all their own rules unless Congress overrides them. And then Congress gets to be the judge of the elections, returns, and qualifications of their own people. So it doesn't say they get to be the judge of the executive branch or others, just of their own people. But traditionally, I think in America, we've looked at things that way. When it comes to the president, though, we don't have the same specificity in the Constitution. And this is one of the reasons why we have the Trump issue right now, is that the Constitution states that each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. And then it says that no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. So the state again appoints these electors, and it says specifically each state shall appoint in such manner as the legislature thereof may direct a number of electors. So the states are in charge of the manner of selection of the electors who vote for president. The Section 5, or sorry, Article 2, Section 1 goes on to state, the Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So Congress gets to choose the day, essentially, the electors vote, when they have to be chosen by. And then, but it doesn't say, again, who gets to determine or resolve the dispute about if an elector is not qualified or if the president is not qualified. So we're kind of stuck in this funny spot of, okay, we know what to do if a representative or senator is not qualified. We, make a claim with the House of Representatives or with the Senate. But who do we talk to about the fact the president might not be qualified? And again, let's just talk about age. If they're not 35 years, who decides that? And can you kick someone off based on that? And so we're at this spot where we're kind of going, wow, this is unique. So if we dig a little bit more into the 14th Amendment and look at what it says, the 14th Amendment, Section 3 was what we read, but Section 5 of Amendment 14 says, the Congress shall have power to enforce by appropriate legislation the provisions of this article. So arguably, Congress has the power to determine, at least through legislation, has the power to pass legislation to enforce the Insurrection Clause of the Constitution and what that means. And I don't think that Congress's power would be challenged extensively in that, but I don't know that, to my knowledge, there's not a specific piece of legislation that Congress has passed on this point. And so then it still begs the question of, okay, Congress has the power to do something, they didn't. We're now at this issue. What does that mean? Does that mean that we can't do anything because Congress didn't do anything? Or does that mean that there's something that can be done? And then finally, as a point, before we go in and talk about some of these pieces a little bit more, kind of both sides of this, Section 3 of the Constitution, and I'll put this back on the screen so that you can see it if you're watching, doesn't specifically mention president. And so some people claim this does not apply to the president of the United States. So it says, no person shall be a senator or representative in Congress or elector of president, vice president, so they can't be part of the electoral college. And then it states, or hold any office, civil or military, under the United States. Some people argue that the president is not under the United States, the president is of the United States, or in charge of the United States. And so some people argue that this only applies to offices inferior to that of senator or representative in Congress. So we have a number of these claims going about. We have some people that say, oh yeah, Trump can be kept off the ballot even if he hasn't been convicted of insurrection in any criminal proceeding. They'll say because this doesn't say shall have engaged in insurrection. And it doesn't say shall have been convicted of engaging in an insurrection. And so, again, some of the play on words, some of the different things going on, because there are other places in the Constitution where it mentions the term convicted, and here it doesn't say convicted. But then that begs the question too of, well, is there due process if you can just be kicked off because someone says, oh, insurrection, and you're out? How does that look exactly? So this is just kind of a quick overview of the 14th Amendment and some of the places it's at. But Michael, I'm curious to know some of your thoughts on both sides, and maybe even some perspective if you have thoughts on maybe what they were thinking. Did they look at things differently back then? Is there a reason maybe that they left the president out of the 14th Amendment? Did they believe that, choosing electors was enough to control who was president? I don't know, just kind of curious if you have any thoughts along any of those lines.
Yeah, I think the first thing to keep in mind is the separation between the federal government and the state government. I know for myself, lots of times when I see things being reported, you see a lawsuit come out against an elector in a state. There's been a few, like in 2016, and there was some, I think, back in the 1960s. Electors weren't voting the way that states wanted them to vote, and there were some lawsuits. It's important to remember the difference between the federal government and their powers and the states and their powers. And sometimes we think that the federal government has the power over certain things when actually the state does. So it's always really important to go back to the Constitution and figure out who you discussed, who is responsible for nominating the electors and how that all works. And that's kind of state power. And so that kind of helps this discussion when we talk about, does the state have the power to do this? Does the federal government have the power to do this? And if it's not clearly defined, like you said, maybe that's why there's a lot of fusion in the courts. That's why some states are saying one thing, some states are saying another. Some people believe a lot of these things come down to, a partisan idea, and maybe some of that's true, but it can also be true that there may just be confusion. And maybe the law has some ambiguity to it. I think that might be somewhat the case here. Just go through some of the history here on the 14th Amendment. We know when it was passed back after the end of the Civil War. And this Section 3 the idea was, hey, let's not allow a lot of these individuals who are leading the Confederate states to now become leaders in the United States. We just got through this war where a lot of people died, and we don't want to continue those divisive lines. What's interesting is fairly quickly on, you mentioned, I think, what part of Section 3 is it? The very end, Congress may, by a vote of 2/3 of each house, remove such a disability, meaning they can say, actually, this person can run for an office. And they said in 1872, Congress passed the Amnesty Act, and it removed the possibility of Section 3 disqualification for most former Confederate officials, with the exceptions of a lot of the high-profile leaders like Jefferson Davis. So Congress has already acted in some respect in regards to this to say, hey, all these individuals that were convicted of treason because they were serving as part of the Confederate Army, they can actually still run for office. It's just most of these high-level officials that we're not going to ever allow. And that was the Amnesty Act in 1872. But for the most part, Congress, like you mentioned, Congress has been pretty silent on this. And the only law I know of in regards to the insurrection clause of Section 3 is U.S. Code 2383. And it's actually really short. I was really surprised because lots of times when I look up U.S. codes, they're really long. But this one was really short. It was passed. Actually, I don't know when it was passed. I have to look that up. It says, whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. What I found really interesting in this code that Congress passed is they use the same language as Section 3, mentioning under the United States, which continues to leave ambiguity about whether it applies to the president or not. Whether I agree or not, I'm still not sure. I think it's fair to say there's ambiguity about whether it applies to the president. I could see arguments going many different ways there. And if we look back at when this Section 3 came about, maybe the thought was after the Civil War, people in the 1800s may not have put as much emphasis in the office of president as we do today. It sounds like when I'm reading this amendment that they had a lot of emphasis in the Senate and the representatives of Congress and their electors. They had a lot of emphasis in the power of the states and the power of Congress, and they expressly gave Congress the power via legislation to enforce this amendment. Today, the feeling is more that the president holds a lot of the power, and we probably see that because there seems to be a lot of gridlock in Congress, and maybe it doesn't move as fast as people would like. And so they look to a president to perhaps move whatever political agenda they have maybe more quickly than they would see coming out of Congress. And I'm not sure if the viewpoints were the same at that point in time, if the president was looked at with as much fervor as it is today. It doesn't seem like it. It seems like there was more interest in state and local government and your representatives in the federal government. So perhaps in writing this, they didn't put as much emphasis on the president, or perhaps it was just a miss, to say the electors of the president, but to not say the president. Perhaps it's just a miss, but we can only really kind of guess at what they were trying to accomplish at that point and just read the writing and try to interpret it accordingly.
Yeah, and I think, to your point about maybe they didn't view the president as having as much power. Agencies that we have currently, so the federal government is huge now because of all these agencies that exist, the Environmental Protection Agency, all these others. Those really weren't a thing until the 1930s. And that was really when the president started getting a lot of power, because the Congress started delegating to these agencies power to actually make law. Prior to that time, the president or anything was over really couldn't make law. The president's oath of office was to enforce the laws. And so this amendment, this Section 3 in this amendment could have been targeted at lawmaking, potentially. And maybe that's why it left out the president. It would still then beg the question of, then why did they include the electors of president in there? Because that seems a little outside of lawmaking. And I've wondered, and I don't have an answer for this. From what I can tell, there's not something, at least that I found so far. But I have wondered if they thought maybe the electors of president, if those weren't Confederate people, they would never vote for a Confederate-leaning president, maybe. And so maybe they felt the electors were the appropriate check and balance as opposed to the president, that office, naming the office. But if that's the case, it would be interesting that you could have someone say, oh, I'm disqualified from running for Senate, so I'll just run for president. Can't be a senator, so I'll just try being president instead. People say, why'd you run for president? Well, couldn't run for Senate because I engaged in insurrection against the United States. And so we laugh at that a little bit, and it does sound a little weird. But again, based on the pure text, you just go, why didn't you just say president if it was meant to include president? And then there's obviously, Section 14 does say any other officer under the United States. And so many people feel very strongly the president's an officer under the United States because we vote for president. And to me, I say, yeah, I'm kind of, I don't know. To me, it does make sense. And I guess technically, we don't technically vote for president. We vote for electors of presidents. And so one of the things it was doing was it was indicating that we couldn't vote for someone that had engaged in an insurrection. So maybe the way it was naming this was to name all the people that we technically vote for, to say we can't go vote for these people that have engaged in insurrection in these states. Now, obviously in the North, if you were a South sympathizer and running, you're not going to go to a state in the North and try and run for these offices. You're not going to be voted in. And the provision, I think, was really targeted at trying to stop a lot of the same representatives that the states already had from being in again. But like you pointed out, Michael, with the Amnesty Act, Congress pretty quickly said, this isn't really an issue. These states are suffering. We've got to rebuild them, all this kind of stuff. Let's just take this off. And so, I don't know. Again, it's an interesting question to look at of, man, why didn't you just say president? But it's interesting, too, to go back to the founders with the Constitution. They specifically said who gets to determine the qualifications for Senate and House, and they never said who determines the qualifications for president, if someone has met it or not. Because it says in the Constitution, one of the ones that could be interpreted somewhat ambiguously is it says that you have to live in the U.S., be a resident of the U.S. for 14 years prior to running. And what does that mean? You could have someone that left to France for 3 months, and so were they a resident of the U.S. or not? It's a question that foreseeably should have been one that I think they would have recognized might produce some arguments at some point. But they didn't put in anything to say who determines these qualifications. And part of me wonders, well, did they not because they didn't worry about it as much? Because in the end, it would be a consensus among states, meaning you could have one state at the time that would appoint a crazy senator or a crazy rep, and maybe they were fudging the rules. But did they believe possibly that as a nation, even if one state put up some crazy president that didn't qualify, that most of the states were still going to only select people that qualified? And so even if one state votes crazy for president, oh well, because the process sorts itself out, as most states would choose to follow it at that point. And so I actually do wonder if one of the things the founders believed was that they didn't need to address the president role as much, because all of the states having to be involved in selecting the president would mean that there'd be some kind of natural selection process involved where most people would follow it. And if they felt that just the generally accepted definition or generally accepted situation, proper interpretation would play out. Because again, if you had Rhode Island said, we're putting this guy up as president, and everyone else goes, he can't be president, you're crazy, then those other electors in all the other states wouldn't even vote for that person. And so it's a system that, again, I don't know. I wasn't there. I don't have specific historical writings on these things. But when I look at the difference in the two, say, why didn't you put in something about the qualifications of president? Well, they might say, well, we had this electoral college, and there's all these people involved in it. And the chance of getting a president through that didn't meet the qualifications is slim to none. And so, again, we're just right now talking about possibilities, talking about possible interpretations of it. As it stands, I think we want to move to talking about some of the possible ramifications, but I think Mike will wrap up first on some of these points.
I just wanted to reiterate, I think you made two really good points there and on the one, it seems like they're focusing on individuals that we vote for or have some sort of direct representation to, where with the setup of the electors, we don't vote for president. We're more involved with who the electors are. And then the second point being, to become president of the United States, it involves winning the electors in a large number of states. And so a state itself isn't incentivized to nominate somebody for president that no other state's going to nominate. They're going to try to nominate someone for president that a lot of it that they feel like has a hold in a lot of other states. whereas a state can put somebody as a state rep in Congress today, both Senate or representative, and it doesn't rely on any other state. It's up to the state to put that individual in. And so perhaps they felt, to your point, that maybe to cover the bases on insurrection needs to be people that the states had the power to send, where the president had to be all the other states together. They felt that was kind of a check on anybody becoming president. One state could decide to do something wild, but because we took care of the electors, and even then, if the electors go sour in a state, they're not going to go sour in all the states. Maybe that was the theory. And so you gotta put somebody up that's going to get a lot of traction in a lot of states. I think those are two good arguments for perhaps why it isn't in here. That doesn't alleviate us of the problem of today, where the ambiguity remains, and we have to figure out what to do with it.
Yeah, and in some ways, if they truly said that the president's not in there, then all this stuff for Trump goes away, because we're only talking about those people we directly vote for, the senators, congressmen, or these other officers. But even then, when it says other officers, it still weakens that claim a little bit, because we don't vote for other officers of the United States. These inferior officers are appointed by the president or with the advice and consent of the Senate. And so there is still this strange ambiguity where they did throw in that other lump of people that aren't voted for. And so then the question is this defined to say, yeah, they said senators, representatives, electors, because those are the three federal people we vote for, but then they lumped in all other officers that aren't voted for by us directly. And so is the president then part of that, or are they not? And so that argument could go both ways, where it's, oh, look, they excluded the president because we don't vote for them. But then does that mean they lumped the president in with any other officer type argument? So yes, to your point, we're back in this conundrum of, well, shoot, what does this mean? And trying to resolve this ambiguity. And obviously none of us know exactly how the Supreme Court's going to rule on these things. We're not here to predict how they're going to rule necessarily. But in talking about the ramifications of different decisions. So currently, states determine qualifications for ballot, people running for office. So here in Utah, I have to go prove to the lieutenant governor's office that I'm qualified to run if I'm going to run for an office. And with that, we have, and so again, that begs the question of, well, if the lieutenant governor's office says, well, yeah, you're not qualified, but we'll still let you run, what happens then? Can people sue, and should the courts then step in to say, whoa, you weren't qualified? And so far, from what I know, courts have been very reluctant to step into that role and determine qualifications. Because again, the Constitution says the Senate and the House of Representatives gets to choose qualifications. They get to be over that. They're the judge of that, essentially. And the courts mostly have looked at this as a political legislative process, where it's up to the legislative, executive side of government more than the courts. And again, I don't know if we've been really strongly faced with a decision where there was a 25-year-old president running, just a clear, straight-up violation of the Constitution, and what a court would do at that point. Because you got to put yourself in the court shoes too. Judges aren't supposed to do what's popular, but let's say that there's a super popular 25-year-old. Everyone wants him or her to be president. And all the states say, we don't care. We're going to put him or her on the ballot. They've got 70, 80% of the vote. Do you want to be the judge that says, no, America, and have 70, 80% of America hate you? Judges don't love being put in that spot. When a person wins an election, the judges kind of go, oh, the people spoke. And so judges really haven't loved that spot. And this insurrection issue with President Trump has really pushed judges to this place, because at the time, right now, Trump hasn't been convicted criminally of insurrection, engaging in insurrection. There is an insurrection criminal law in the books that Congress passed. And so some people could say, if he's convicted of that federal law that Congress passed, because Congress has the power to enforce the 14th Amendment, therefore, if he's convicted of that, keep him off. But to my knowledge, Trump hasn't been accused of that specifically. He's been charged with other crimes that relate to that, but not directly the insurrection one. And so we have this spot where, again, it's kind of this question of, well, what happens now? In Colorado, the lower court judge, the district court judge, took extensive findings of fact. So there was some type of evidentiary hearing that went on. I don't know. I don't think it was a full traditional trial with the speed involved. But the judge did go through and make 100+ pages of factual findings. And so there was a judicial hearing where a judge determined that Trump engaged in insurrection. So there's a lot of people that say he hasn't been convicted of insurrection. It's true that he hasn't been criminally convicted of insurrection, but a judge looking at the insurrection clause ruled that Trump engaged in insurrection. So there have been judicial proceedings that said, yeah, he engaged in insurrection. Now, that then begs the question of, but what do they do? And the Colorado Supreme Court looked at those findings and said, yeah, this is insurrection. Yeah, Trump is an officer under the office of president is an officer under the 14th Amendment, therefore we're going to keep them off. And so again, going back to this, we have this interesting scenario where if the Supreme Court says, this is up to the states to decide, we could have a situation where a person is on the ballot in some states and not others. And that sounds a little bit outrageous to a lot of people, but it actually has been happening in America for a very long time. If you aren't a member of the governing political party, the Republicans or Democrats, and you're trying to get on the ballot, you have to qualify in all 50 states. And you may be on the ballot in 2 states, you may be on the ballot in 30 states, but not on the ballot in all 50 states. And right now we have Robert Kennedy running for president as an independent. He qualified here in Utah, but he's still working on qualifying in other states. So he'll be on the ballot in Utah. It's not guaranteed yet that he'll be on the ballot in all states. And we've been fine with that for third parties. As Americans, we haven't cared a whole lot because we don't vote for them a whole lot. But when it comes to Republican potentially being split and not having a clear candidate on the ballot in all states, there's suddenly a lot of consternation about it, and people are upset. And again, it goes back to this interesting scenario of maybe what the founders were thinking with voting for president. If you have a party that wants to put up a candidate for president and some states rule and say, nope, that candidate doesn't qualify, you can't get on the ballot, then do you want to continue running that candidate if they can't qualify in all 50 states for president? Or do you pick someone else? And that's a decision for the party, that's a decision for the states, for the people, for the electors that vote for them. But in general, states, the natural check and balance is the states want to put up someone that can be on the ballot in all states. Now, the Republican Party may not care about Colorado, it may say we're not going to win it anyways. They'll go for the Democrat nominee. But it's one that they'd still have to consider and deal with. Same with Maine. These states where you could pick back up electoral votes, and what's your strategy at that point? And so there is potential for the courts just to say, every state gets to decide. And with that, we could have a fractured type election where it's not a unified approach to the president. My opinion on that right now is if the courts go that way, we're already, I'd say, I'm not pretending like we've never been more fractured in America. Before the Civil War, things were quite fractured. During the Civil War, things were quite fractured. But there's a lot of fracturedness in our society currently. And something like that would create a lot more if people in a state couldn't vote for a candidate that people in another state could on a very large level. And so that's one potential outcome. Another potential outcome is that the Supreme Court kicks it to Congress and says, hey, Congress, you got to pass some legislation here. You need to fill in this gap because you were told you could enforce this through appropriate legislation. So come enforce this now. Come tell us what to do. And that would be a very interesting scenario. If the court said, yeah, this isn't our fight, but Congress can step in if they want to. And obviously, with how political things are, I don't think it would be viewed on principle. I don't think there'd be a fair shake at whether someone qualified for the ballot or not. But it is, again, what do you do when Congress hasn't acted and it's just sitting there? And this was an issue that happened here in Utah. Not this exact issue, but one where the legislature hadn't acted yet. The Utah Constitution says that citizens have the right to do a referendum, which is to gather signatures to try and overturn a legislative action that took place. If you can get enough signatures, you can get it placed on the ballot for everyone to vote on. And so they can nullify an act of the legislature if they want. It's a constitutional right granted by the Utah Constitution, but it says in there that the legislature shall set up the details associated with how to do this. And there was a property tax increase that came up from a school district, and school districts hadn't been specifically included in the Utah law passed by the legislature. And so there was this right where it said you're supposed to have the right to overturn this by referendum. But the legislature didn't detail a process for how to overturn school district one. And some people took it to the Utah Supreme Court saying, hey, court, you need to fill in here. And the court said, no, we can't fill in the gaps. We just kind of got to wait for the legislature to do something about this. And it was interesting to see the court kind of wring their hands dry and say, yeah, it's a constitutional right, but they didn't fill in the gap with legislation, so we can't do much about it. And so there are some rights the courts kick solely to the legislature, and they put it in their hands. And I believe that there has been a state or two that the courts have done that same thing. They've said, it's up to our legislature to determine whether this person qualifies or not. It's not on us. And the Maine Secretary of State took that initiative and said, yeah, it's not the court's decision. It's on me because I'm over elections. And so I'm making the determination. Now, again, if you let the state legislatures do it, it could still be subject to some yes, some no. And one of the concerns to me is just how partisan politics could get, where all the Democrat states say, yeah, that was insurrection. All the Republican states say, no, it wasn't. I don't personally feel that's the way that a federal constitutional amendment should be interpreted, is based on partisan politics. And if we kick it back to the states and others, we're opening the door to just partisan politics all around. And so when I look at it and the possibilities associated with it, I say, I can see why people push the Supreme Court to do something about it. But if the Supreme Court gets involved, either way, it'll be accused of partisan politics. And I don't know how the Supreme Court avoids that unless they just punt it to the legislatures, either the state legislatures to say it's on you unless Congress overrides you, or to say federal Congress needs to sort this out. And Michael, I'm curious if you see any other options or problems or benefits of any of the possible solutions.
Yeah, I don't know that I see a lot of other options, not being as familiar with the law, but what does interest me is the way that these kind of arguments get framed in popular news feeds or amongst people, and compared with what's actually going on, meaning sometimes we I've heard people look to this proceeding to try to justify their opinion. Hey, the Supreme Court's going to rule on if Trump committed insurrection or not. And that's not, that doesn't have to be the case here. Supreme Court doesn't have to make a ruling on whether or not what he did was insurrection or not. And the outcome of this, people will say that it might rule one way or the other. But I think we need to open up and understand it's not always that simple when it comes to the law. Sometimes something happens, right or wrong. There's a challenge that's sent to a court, and they don't always necessarily rule on the thing that happened because they have to look at what the law says about the thing that happened. And so, to your point, this could come out a lot of different ways. Supreme Court could take this many different ways, and maybe a way that we haven't even talked about. And they could say, this was insurrection. They could just avoid that question entirely and just talk about what rights states have and putting people on ballots and all kinds of repercussions could come out of this. So when we look at challenges to the law, I don't think we always look at what the consequences of our challenges to the law could be. To your point, if they come out and just punt this back to the state legislatures and we become even more fractured as a nation, did we, I say we collectively, but when we started down this path of indictments and trying to prosecute the President of the United States, did we decide, actually, we're just going to make the United States even more fractured than ever before? We're not actually going to solve anything. We're going to make it worse. And I'm not putting that out there to say we shouldn't do the right thing or, advance certain take certain people to court over certain things. But I think we need to open our eyes to the bigger picture that all of our actions have consequences, and they might not be the consequences we have in mind. They can make things worse, they can make things better, but we need to be very careful when it comes to the law because the outcome isn't guaranteed. It could be that we're reading the law incorrectly or somebody else reads the law differently than we do. And there's, due to the nature of language and the way we write things, and as we've outlined here, maybe just a missing piece of instruction, these things can get really messy really fast. And so I think we need to, use some, we need to look ahead a little bit better and say, what are the long-term consequences? Let's say this doesn't go the way I want it to go. Let's say it doesn't go the way my opponent wants it to go. It goes some way entirely different. It's just a reminder to me to be careful of when we turn to government, when we turn to law, say, hey, solve this for us. The outcome isn't guaranteed. It could be based on how we've written law, based on the language. It could be something we didn't anticipate, and it could end up being entirely worse than it was at the beginning. And so this isn't to say don't pursue law. This is just to say use care and caution.
Yeah, and I think it's an interesting question too as to the role of the courts. Again, it begs the question of should the courts fill in legislative gaps that exist? The Utah Supreme Court said, no, we're really not comfortable going there. We're not going to fill in a legislative gap that exists. And, is there a loophole? Does something weird happen that maybe is cleaned up and never happens again? Some of those things might happen, but going back to our discussion about due process, one of the things about the due process requirements, even in the 14th Amendment, are that you have to have notice of the law. And you have to have notice of some of these things. And some people would say, yeah, there's notice you can't engage in insurrection. But even then, the question is, well, what is that? Is that speaking to a group who then attacked the Capitol building? Because there was, to my knowledge, there was 1 million or so people there at the rally. I'd say that 99% of them didn't go attack the Capitol. Now, I'm not necessarily saying it is or isn't insurrection. It's just to say that, if I'm out speaking and someone goes and lights a police car on fire and says, well, Austin told me to do something about this problem, have I then engaged in insurrection? Because someone decided to do an action that wasn't specifically called for. Now, I do know with Trump there are divided opinions on whether he engaged in insurrection or not. But it is, to your point about the precedent set, if you can disqualify someone by simply listening to something they say and then going in and attacking something or someone, any group could go riot after someone meets and disqualify someone. Now, some people will say Trump did more than just speak. This judge in Colorado found there's quite a few findings, quite extensive production of documents and things. And so I haven't gone through all those myself. I don't know the extent to which it did or didn't happen, but I do know that there is some very concerning precedents on both sides in this. And I do think it's a very, very nuanced, very factual, very deep, principally driven issue that America is facing currently. And a lot of people have talked about how surprised they are the Supreme Court took it up. They're going, oh, no one's going to like the Supreme Court after this. But when I look at the issues, I go, well, I actually have high respect for the court looking at it going, oh, this is a mess. We need a federal, a unified consensus to things here. Again, whether that's just kicks back to the states or kicks to Congress, or whether the court steps in and says, no, this is actually what the Constitution says. And this is how we interpret it, and this is how it applies. We're putting an end to all these questions. To me, the Supreme Court, I think, feels a great duty to help resolve questions like this and to do something about it. And I think they all recognize that people aren't going to like them after it. There's going to be essentially, if you go off just voting numbers alone, half the country will be upset at them and half the country will love them. Then they may find a way to punt it and deflect some of the blame, but the news is still going to cast in a certain way to say the court voted for or against Trump, however that works. When there's really a lot more principles. There's a lot of principles, and I really hope that just if you took the time to listen, that you recognize there are issues at play here. They're not just simple, we pick a winner or a loser, but we're looking at, and I actually believe the court will look at future precedent, because they're still grappling with things like Trump's claims that he has presidential immunity and can do whatever he wants. Now, if you factor that type of thing into this insurrection side of things, I think any court, appointed by Trump or not, are going to be concerned about the potential ramifications of that type of argument. And there's a lot of precedent that could come that'd be bad as a result of decisions like that. And the courts always weigh policy decisions and the long-term impact into their decisions, because, again, from the perspective of America and what really governs in America, we make this plug quite often, but there's really a morality that governs these constitutional interpretations. And the courts will look to what's necessary to keep the country together, what's necessary to create good precedent, to create a strong system that functions, and they'll make decisions based on that. And if arguments are too outside something that allows the system to function, they often won't adopt that interpretation. They will go with an interpretation that is that allows the country to continue to operate and continue to work as it has. And so I wouldn't be surprised if we see the court lean into an interpretation that allows for there to be a functioning system. One that says, yeah, there is some kind of central authority. Maybe the court takes it on and says, we're the central authority until Congress acts. Maybe they say, this is your incentive, Congress, to go fix this problem, work together and come up with some solution. But until then, this is the patchwork option. Or they just say, no, this is what the Constitution says. Or again, it could be easy just to say, yeah, 14th Amendment doesn't apply to the president. And people will still interpret that to mean that the Supreme Court sided with Trump. But one of the differences too, so if you go back to Bush v. Gore, the Supreme Court in 2000 got involved in the election dispute between Bush and Gore. They were neck and neck throughout the whole country. Electoral votes, they came down to Florida, the state of Florida. If Florida went to Bush, Bush would win. If Florida went to Gore, Gore would win. And Bush and Gore were so close. And so a recount was ordered. And Bush's group sued to stop the recount, because as the recount was happening, it was looking like Gore was getting more votes. and the Supreme Court agreed and stopped the recount. That one, it looked extensively like the court picked the outcome of an election. In the Trump case, no matter what the court decides, there's still a whole election to happen. And so we're at a place where, yes, you might be able to say the court got involved in picking a candidate, but we as Americans, no matter what comes out of this case, still have the right to vote for president. Now, maybe there will be people that can't vote for Trump if he gets disqualified, and they could be very upset about that. But there will still be a presidential candidate they could choose from. And as opposed to the court after the fact, and after you've cast your vote, the court then picking who wins. And so I do think this is a different scenario. I do think the timing of it has given the court time to be involved and to hopefully make some meaningful determinations here. But I don't think they have a lot of great material to work with. And, the Constitution, I believe, is great. I love the Constitution, but I will readily admit when there are holes or things not covered, and this is one of those situations. And so the Supreme Court will meet this week. We'll talk about it. They'll issue a decision probably in a week or two before most of these states are holding their conventions. And I guess, in some states, Trump has already been voted on. So we are at a place where some Americans may have cast a vote that could be ruled to not apply. But for most of Americans, they would still have that ability to vote for someone else. Or if you don't like Trump and Trump stays on the ballot, to not vote for Trump. That's still an option. And that option will stay no matter what. And so I think that's one of the bigger things is the court may look at this and say, with the ambiguities, with everything involved, if the states decide and people vote for him, great. If they don't want to vote for him, then don't vote for him. It's a way for the Supreme Court to return that vote to the people, just to say, let Trump on the ballot for right now until Congress acts and passes something definitive in this regard. So again, we'll see what happens. We don't know. But in the area of law, in the area of cases, this is certainly an interesting one. It's a gap filler measure where there's nothing specific on point. And it's one where I think it begs the question extensively to American citizens, which is, if there's an important issue like this and the law is missing coverage of it, what's the proper resolution? And we're not talking just this case, we're talking in general. Should the court step in and fill in that gap, or should they just say, sorry, Congress didn't do its job, and leave it at that? And I think that is something that should be discussed extensively. No matter how many laws we have on the books, there's still loopholes that come up, still strange situations that occur. Do we want the judges filling in the cracks? Or should they just say, sorry, this wasn't addressed, and leave it at that? Michael, I don't know if you have any final thoughts or things you want to pass on.
Just reiterate that point. Take care when we seek to the law for solutions. I mean, we kind of should go in with the idea of the principle in mind, like you say. Before we look at a gap and say fix it, we should say what manner is there a principle we can apply to this that we should be shooting for? If you think that we should send it to the judicial branch every time, sure, state that principle, state your reasons. This is why it would work out best. If you want the judicial branch to say, no, there's no law on this, we're not going to make a ruling, run with that, argue that, state your principles. I just think too often we look at something that's broken and just say fix it, and we don't get a good idea of the principle or process in mind, and it can get messy. So we should just take care when it comes down to those things.
Yeah. So I'll be interested to watch the Supreme Court, what they do. I do pray they are blessed with a lot of wisdom. And that is one prayer I have, is that they can have a very wise solution to this issue. One that helps in some way bring our country a little closer together. Or that people can at least look at and say, yeah, was wise, and that was some solid wisdom on these issues. I sincerely hope they come up with something I haven't thought of. And so that will be one of my prayers this week. And I'd invite you to have the same prayer. We don't need to view this as much as a fight over who's president, but really of some bigger implications for our country. And is there a wise solution that can come out of this? I believe so. I hope so. And I will certainly pray for that. But thank you for joining us today. We will continue with these discussions. Should be wrapped up with the 14th Amendment. Quite the amendment. There's a lot packed in there. And we will talk to you more next week. Thanks so much.